I've been a prosecutor for 20 years, state and federal prosecutor. And to me, at least, that is a very long time. And I would say that over the course of my career, handling cases from misdemeanors to felonies, state and federal cases, one thing that has become very clear to me as I have frankly gotten older is the impact on a felony prosecution, in particular on someone who has moved through the felony system and is ready to take the next step in their life. And to me, based on that experience, what I have found is that things like getting a job, or getting housing, or getting financial aid to go to college, having a felony conviction is a major impediment to all of those things. Now, there are circumstances when having a felony conviction is certainly appropriate. And I have prosecuted many people who have gotten felony convictions. I prosecuted many people personally who have gone to jail for a very, very long period of time. But there are other individuals who I believe would benefit from a change in the law. And to me, that is people who possess small amounts of any kind of narcotic. Now, this bill, what it doesn't do is protect dealers. So if you deliver narcotics in any amount, my office will prosecute you and prosecute you aggressively. If you possess any amount of narcotics with the intent to deliver it, we will prosecute you and prosecute you aggressively. If you possess over 1 ounce of any kind of narcotic, we will prosecute you as a dealer and we will prosecute you aggressively. But the instances that we're talking about here tonight and that are covered by the scope of this bill, I believe do not fall into that category. I do not view someone who possesses a small amount of narcotics because they are an addict as a felon. I view that as misdemeanor conduct, and to me, that is what this bill hopes to address. Now, since the original introduction of this bill, we have had many conversations in the office and outside of the office with potential stakeholders. And as a result of those conversations, there are adjustments to the bill which I suspect or I subject will be ultimately brought before this committee. And I'd like to go over those if I could. One of the concerns that was expressed to us was who would handle these cases as misdemeanors. And the concern was one of consistency. My office, under the typical practice, had these cases returned to the district court and were handled as misdemeanors there. City solicitors or town solicitors would handle those cases. I have a ton of respect for city and town solicitors. But one of the concerns by stakeholders here was that there would be a lack of consistency were city and town solicitors to handle these prosecutions as misdemeanors. And so I have committed, the office has committed to handling these cases ourselves. And so these will not be cases that are passed to city and town solicitors. My office will continue to handle them if the bill is passed. The current bill does not specify where jurisdiction would lie. After conversations with both the court and with stakeholders, it's my view that while the district court could adequately handle these cases, I believe that jurisdiction would best lie in the Superior Court. And here's why. I believe that to be the case because there are existing courts in the Superior Court that do this work all the time and do it well. So for example, the drug court does terrific work. I know many of you, if not all of you, have seen the work of the drug court. It does terrific work. So if these cases were to lie even as misdemeanors in the Superior Court, there'd be a simple and easy pathway to the drug court. I also believe that Superior Court is the appropriate place for these cases because we are right now working with the Superior Court to establish a diversion court. That diversion court is authorized by the judicial reinvestment bills that were passed by this legislature a couple of years ago. I support those bills in their entirety, and I'm working with the Superior Court to get that diversion court up and running. I would propose to use the 3 employees that I have working in diversion in conjunction with the court personnel to put together a combined entity, if you will, that would handle these cases. And I believe that we could send these cases to the diversion court if necessary, if the drug court wasn't a good fit. So Superior Court would give us multiple options. I also believe that allowing these cases to stay in the Superior Court would frankly give us some time to address them. As all of you know, many of you are practitioners, certainly all of you know that the district court works very, very quickly. And having the Superior Court pace when you're dealing with an addict, I think would be a positive step. There are two other concepts I want to share with you that I think that another version or the next version of this bill ought to take into account, and I will propose them. One is that these offenses be classified as 2-year misdemeanors rather than 1-year misdemeanors, and there is some precedent in Rhode Island law for that. I believe that practicing veterinary medicine without a license is a 3-year misdemeanor. I believe that to be the case. So there is precedent for it. It can be done. Here's why I think a 2-year misdemeanor is appropriate. I think it reflects that this is a different misdemeanor than many others. I also think that someone in recovery may take longer than a year to reach the end of that recovery path or that recovery runway. That allows us, as prosecutors, and more importantly as a court, to have a 2-year hold over that person while they go through recovery. The reality is that people who are addicted to narcotics and possessing small amounts of narcotics are not getting jail right now. So what this really is about is a hold. It really is about a hold, and I think a 2-year hold is appropriate. The last concept I want to share with you is something that we have been in discussion with our partners in law enforcement about, and that addresses should we draw a line between 1 ounce and a lower amount in which a 3-year felony would remain in effect. And that is a concept that we're still discussing with our law enforcement partners. And so, for example, where might that line be drawn? It might be drawn at 1/2 ounce, where above a 1/2 ounce of a Schedule 1 or a Schedule 2 controlled substance would remain a 3-year felony because of the danger of those narcotics, and because in some of the smaller cities and towns, there's a concern that that amount may be a distribution amount. So we're still in discussions with our law enforcement partners about, but that is a concept that in concept I support. So those are the main features of the bill, as well as some of the adjustments that we are prepared to offer for your consideration soon, I hope. But overall, to me, what this comes back to is recognizing what felony conduct is, focusing our resources as prosecutors on people who drive this opioid epidemic that we have, focusing our attention there and making sure that people who are addicted to these substances get the help they need, and continue, frankly, to use the bully pulpit of my office to advocate for accessible and affordable treatment. But once they're through recovery, once they're on the other side, they have a chance to get it right. And we are not, as a society and a state, putting obstacles in their path. And I will say, this is not a novel concept. There are 20 other states that do this. And I guess I'll end my comments with this. When I was a young prosecutor in Courtroom 9, I prosecuted people for possessing a needle and syringe. That was a 5-year felony at the time. And some of those people went to jail. And I prosecuted those people and sent them to jail. Obviously, I recommended jail to the court, frankly, without thinking about it. And I look back on those days and I regret that. And it also tells me that at the time, we were concerned about how eventually, when that change came about, that was no longer a crime at all. There were some folks who thought that the sky would fall. And it did not. Times change, and I believe that this bill reflects a change in times and reflects justice, and that's why I have proposed it, and that's why I support it.